All right, I'd like to call the conditional use hearing to order, and I'm going to turn it over to our hearing officer, Tom S.D. Esquire.
Thank you, Mr. Chairman. This is a hearing on the conditional use application of the Klein Company. They own a property with a postal address of 830 Horseshoe Pike. The applicant's requesting conditional use approval pursuant to section 399-25B10B of the East Brandywine Township zoning ordinance to serve proposed dwellings in a clustered residential development with a public water supply. I have several exhibits to mark and make part of the record. Exhibit B1 is correspondence of Louis J. Colagreco, Esquire, dated April 10, 2025, enclosing the conditional use application. B2 is correspondence of Louis J. Colagreco, Esquire, dated May 20th, 2025, extending deadlines for commencing the conditional use hearing. B3 is another letter from Mr. Colagreco dated October 7th, 2025, requesting commencement of the conditional use hearing. B4 is electronic mail to Ryan Furlong dated May 9th, 2025, enclosing the sign which must be posted on the property for the notice of the conditional use hearing. B5 is proof of publication of public notice of this hearing in the Daily Local News on October 20th and October 27th, 2025. B6 is correspondence of Nathan M. Klein, P.E. Pannoni, the Township Engineer, dated May 2nd, 2025. Since this is a conditional use hearing, there is an opportunity for members of the public to become parties to the proceeding. I don't see anyone here that I don't recognize. I presume that nobody wants to request party status. Seeing none, we can move on. I see Mr. Ryan Furlong here representing the applicant. You're free to proceed with your application. Oh, I'm sorry, I forgot one exhibit. B7 is minutes of the East Brandywine Township Planning Commission meeting of May 7th, 2025. Mr. Furlong.
Good morning. My name is Ryan Furlong. I'm an attorney with Riley Riper here on behalf of the applicant, the Klein Company. We are here this morning, to discuss the property at 830 Horseshoe Pike, UPI number 30-6-39. It's approximately 17 gross acre parcel that the applicant is proposing to develop with 7 single-family detached dwelling units in a residential cluster development, which is permitted on the property pursuant to section 399-27A2 in the R2 zoning district. Before I get into too many details of the application, just wanted to mark some procedural exhibits as well. Exhibit A1 is the applicant's conditional use application with addendum. Exhibit A2 is the East Brandywine zoning ordinance incorporated by reference. Exhibit A3 is an affidavit of posting from a paralegal of my office indicating that the property was posted as required by the MPC. Exhibit A4 is a letter of authorization from the president of the applicant entity, who is also connected to the property owner, just establishing the relationship between the property owner, the applicant, and the authority of Chris Daly here from Howell Engineering to testify if necessary. And Exhibit A5 is a property deed dated January 2nd, 2002 between Yvette S. Means as grantor and Arbor Hills Associates as grantee. Given the nature of the application, as Mr. Esty mentioned, we are requesting conditional use approval to allow these dwelling units to be served by public water under section 399-25A or B10A, of the East Brandywine zoning ordinance. Residential cluster developments are to be served by groundwater or well water. However, section B10B allows this board to grant conditional use approval for public water if that public water service is available and it won't cause any additional detriments to neighboring properties. Given the nature of the application, I was wondering if the board would be interested in me providing an offer of proof, just explaining the application, what Mr. Daly would testify to if he were called to testify, and then I would ask Mr. Daly at the end of my presentation if everything I said was accurate.
I would recommend that to the board unless there's some objection. Please proceed.
So if called to testify, we would introduce Mr. Daly's credentials as a professional engineer, licensed and certified in the Commonwealth of Pennsylvania. We would request to certify him as an expert in civil engineering to then walk the board through the site plan that is presented on the board and is also attached as Exhibit A8 in the applicant's application package. Beginning with Exhibit A7, we would walk the board through a property aerial taken from Chesco Views, just establishing the residential character of the surrounding area before walking through this site plan that's before you. Mr. Daly would explain that the development would be served by two individual access roads that would be taken over access easements that the applicant has over the neighboring property to the south in Klein Township. You'll see there's a single driveway that will serve 2 homes on the east side of the property and a cul-de-sac road that would serve 5 homes on the west side of the property. Given the net tract acreage of the property, a residential cluster development is allowed 7 dwelling units, as is shown here. All 7 of these dwelling units comply with the area bulk lot area standards of the R2 zoning district. The cluster development regulations also require a certain percentage of common open space be maintained. Here, given the tract acreage, 10.19 acres of common open space is required. We're providing slightly more than that at 10.4 acres. After walking through the plan, we would introduce that access and utility easement that I referenced as Exhibit A9, in addition to allowing access through those 50-foot wide easement areas that are illustrated by a dotted line on Exhibit A8. That easement agreement also allows the carrying of utilities such as public water to the site. Would then ask Mr. Daly to walk through the conditional use standards to allow public water service, as well as the general conditional use standards of Section 399-137. Mr. Daly would testify that there is water service and capacity available, as indicated in Exhibit A10, which is a will-serve letter from Aqua, Pennsylvania. He would testify that allowing public water to this site would not detract or cause harm to neighboring properties. In fact, there'd be a benefit to the residents of this community by allowing fire hydrant connections in the roadways, which would not be possible if we were just doing individual well water service. He would testify that providing public water service here would not have any impact on public services. It would not increase the density of the project, whether well water or public water is provided. 7 dwelling units is permitted under a residential cluster development on this site. He would testify that it is consistent with an environmentally sensitive approach to land planning, as providing this public water connection won't require any additional soil disturbance, since the water lines would be built in connection with the roadway connections. He would testify that it is consistent with land use policies of the township and the township's comprehensive plan, as public water service is permitted if these standards are met. He would testify that providing public water service would not have any impact on screening or buffering of the property. By doing a residential cluster development, we'll actually be preserving much of the existing vegetation that's on the site. He would testify that the public water service would not cause any additional disruption or to the topography of the site, It would not have any impact on historical resources, and the development would comply with the erosion and sedimentation and stormwater management requirements of the township's zoning ordinance. We would also note, as Mr. Esty introduced the Planning Commission minutes, that we appeared before the East Brandywine Planning Commission in May to present this proposal, and the Commission recommended approval. And at that point, Mr. Daly, everything I say
He has to be sworn in unless
Yes.
I missed that.
Sorry about
Sir, from the testimony, to give only the truth, the whole truth, and nothing.
I do.
Mr. Daly, did you hear everything that I just said? And if called to testify, would you adopt that as your own?
Yes.
If the board has any questions, we'll turn it over at that point. I would note that this is the first time this board is seeing this application, but it won't be the last time. We have also filed a land development application. We hope to be back before you in December of this year. We understand that a review letter of our land development application will be issued by Mr. Klein, your engineer, either today or tomorrow, at which time Mr. Daly and Mr. Klein will sit down and work out any land development issues that have been identified by our engineer, and hope to be able to discuss those in detail with you in December.
Can I get a landmark of where this project is? What development are you tapping into?
It's the My Place
Place.
development
So
in
it's
town.
tapped to that?
Yes.
Okay, and how does that?
Township approved this development as a planned residential development. A condition of that approval was that if the developer intended to connect this property to the My Place development, they had to go back and seek approval of Township.
Yeah, I remember it from
That-
a while ago, but I couldn't
yeah.
remember all the details.
That is in process at this point. The applicant has made that request to Township.
And what we expect to appear in Township the second week of December. I believe it's the Thursday, which is before your scheduled December meeting. So we'll have spoken with them about this project at that time as well.
And for record purposes, the common driveway tap-in is Township. The property itself is, all properties are located in Brandywine Township.
Yes.
And how would that work with responsibility of, is My Place, Township maintaining the roadways, or is that the association?
So Township accepted dedication of that Boulevard Road, the main, I believe it's Gendry Boulevard. The HOA there will be an HOA established in Township for the My Place community that is maintaining the other roads on what we call Lot 2, so that the west side of the Township property, those roads are going to be maintained by the 200 townhomes that are being served. The units, these 7 units, will then share in those maintenance responsibilities. So in the access and utility easements, that is Exhibit A9, it outlines basically how you would reapportion those costs once these structures are completed and occupancy permits are issued.
I was just thinking, because how would that play out if there was a lien or somebody wasn't paying their HOA fees? Town lien, but it can't be liened on that property, can it, if it's in East Brandywine?
It's something that the developer of the Cowan property also had Fernmore, which our office represents, and we're working through that as well. I think in the grand scheme of things, we're not talking about a high share of cost for these 7 homeowners. I think we've been discussing legal ways that the HOA would be able to enforce against these properties.
And as Mr. Furlong indicated, actually, there has to be a hearing before the zoning hearing board. I guess that, or does that already occur?
No, that's next week.
Right, for steep slope disturbance. And there's also a pending application here for subdivision and land development. And there are other issues that need to be resolved,
Sure.
like police services and trash hauling and recycling removal. And I presume that we're going to address those all during the land development process.
Yes, yeah, we expect, we've been looking at certain intermunicipal agreements that, we would bring to this board to work out. Helpful that Mr. Hesse's office also represents Township, so.
Another issue is that, whether the East Brandywine Township Police is going to traverse private roads in another township to access the 5 lots in the back. So we need to discuss and resolve those things during the land development process. So, is there anything else, Mr.
I have a
Clark?
question.
Oh, so I'm sorry.
I thought you said the boulevard's going to be dedicated.
Well, only up to, and I'm not sure where that dedication ends, but the 5 lots, I call it in the back, they access private roads. That's not
Okay, so they
dedicated.
don't empty onto the boulevard.
Well, eventually they do, but you have to wind through the
Right,
development
right, okay.
on private roads to get
Okay.
to that boulevard.
Yeah.
For additional clarity, I guess when you went to Callan, you were originally proposing public sewer and public water. So explain to us what took place in Callan that now the public sewer is off the table.
It's more of a operating territory for the sewer authority. They are not allowed to extend
And we're
into.
not part of that sewer authority.
Exactly.
Okay.
Right, they're part of Darren, right?
Exactly. So
The Township sewer system is owned by the township, I think.
Yeah.
And they cannot provide extraterritorial service.
Yeah.
Mr. Chairman, may I pose a question?
Yes.
So this is just my unfamiliarity with what you've marked as Exhibit A10, which is the will serve letter from Aqua. Earlier we heard that a particular advantage of public water is the provision of hydrants, fire hydrants. I note that Aqua doesn't reference fire hydrants in their will serve letter. Is that typical, or is that just, do they make assumptions that if they're extending a main, there will be new fire hydrants?
Yeah, this letter is just a broad will serve, like they'll provide service because we're in their territory, but there's more work that's involved with Aqua in terms of, hydrant capacity and that sort. But we do anticipate repairing the hydrant as we want to.
Thank you for that.
Any other questions? Any questions or comments from anyone in the audience? Seeing none. The board has 45 days from the close of the record to make a decision. I would suggest that you make this decision on December 18th at your December 18th meeting. So that'll give the applicant time to at least make the presentation to council. We'll have that information by then. If that's not, I'm not sure if it's within the 45 days or not. If it's not, will you grant the board an extension until December 18th?
yes.
Thank you, to make the decision. Thank you. If there's nothing else, we can close the record. Thank you.
I would just ask my exhibit to be entered into the record. Thank you.
Thank you.
Thank you. Thank you.